right, good morning, everyone. We are on the record in CR 2024-006850. And because many of you are here in different capacities and some are not here from yesterday, let's start with the state and go through everybody announcing their presence and whether their client is here or whether the appearance is waived.
Good morning, Judge. Assistant Attorney General Nicholas Klingerman on behalf of the state.
Good morning, Krista Wood on behalf of the state.
Good morning, Your Honor. Casey Ball on behalf of the state.
Thank you.
Good morning, Judge. Andrew Marcantel for Senator Kern, who is present.
Good morning, Your Honor. Ashley Adams on behalf of Dr. John Eastman, who is on Teams with us this morning.
Okay.
Good morning, Your Honor. Mark Williams for Rudolph Giuliani. He's not present, and I'd request a waiver of his presence for today.
Thank you.
Good morning, Your Honor. Brad Miller on behalf of Doctors Kelly Ward and Michael Ward. Kelly Ward is present here, and Dr. Michael Ward is actually via Teams, but he'll be in and out because he has patients today.
Thank you. Good morning, Your Honor.
This is Thomas Jacobs on behalf of Christina Bob. I'm appearing by Teams. My client is not here. I'll waive presence.
Thank you, sir.
Mike Bailey on behalf of Boris Epstein, whose presence is waived.
Yeah.
Yeah, apparently it's not working.
All right, if the acoustics are terrible in here, so if you could just,
Mike Bailey on behalf of Boris Epstein, whose presence is waived.
thank you.
Can you hear me, Your Honor?
I can.
Okay. Dennis Wolinchek and Lacey Cooper here on behalf of Mr. Lehman, who is, as you see on screen, not as nice an office as Mr. Eastman, but here nevertheless, and I hope he can get on. It looks like he's muted right now, but he is here, Your Honor.
Thank you.
Good morning, Judge Stephen Binhack and Andrew Pacheco. We're here for Tyler Blair, who is present in the courtroom.
Thank you, sir. Okay.
Good morning, Your Honor. Ann Chapman on behalf of Mark Meadows.
Okay, thank you.
And good morning, Your Honor. Kurt Altman and Ashley Fitzwilliams, and I believe Patricia Gentry is online on behalf of Michael Roman, and we ask that Mr. Roman's presence be waived.
Okay, thank you.
Good morning, Your Honor. Danny Evans and Amanda Lauer on behalf of Robert Montgomery, who's out of custody and not here. Respect for waive his presence, and we also respect the excuse us for the proceedings.
You want to be excused for the rest? So you came down just to say good morning? Thank you.
Just waive my client's presence on the record.
I appreciate that, and have yourself a great day.
Thank you.
Thank you.
Good morning, Your Honor. John Dawes on behalf of Nancy Cottle. We're going to ask to waive her appearance. She has a medical appointment. She's going to come in and out of Teams.
Okay, that's fine.
I'm sorry, I didn't get your name.
John Dosdell, D-O-S-D-A-L-L. Good
All right.
morning, Mike Colombo on behalf of Senator.
Sorry, you have to speak up.
Good morning, Mike Colombo on behalf of Senator Hoffman, who is here today. I'm here with Jesse Franklin Murdoch and.
So you were enjoying our weather so much you decided not to fly back?
The decision was
Okay, well, thank you for being here. Did we miss anybody? All right. And for the parties who were here, good morning to all of you, and who are, I know that, I think my camera is somewhere around here, but I see you off to the right, so good morning to all of you. We are continuing the argument regarding the anti-SLAPP motion, and I was telling a colleague last night how much I appreciated your effort to coordinate this. I just wanted to express that again, and I'll turn it over to you, Counsel.
Yes, Judge, just wanted to give the court, for scheduling purposes, a brief update of the list of speakers who plan to speak on the anti-SLAPP motion. As mentioned yesterday, we're going to start with Mr. Miller, who represents the wards, and then we're going to be hearing from Mr. Jacobs for Defendant Bob, and I believe he is appearing virtually. And then also would like to address the court on this point. We have Mr. Bailey, who is counsel for Epstein. We have Mr. Wilenchik, who is counsel for Hoffman. Oh, Mr. Lehman, I apologize. Mr. Williams, who is counsel for Mr. Giuliani, and Mr. Altman, who is counsel for Roman. So there will be a total of 6 more speakers. And this could be a non-exhaustive list again, Judge, and I'll try to make sure everybody stays on task with it.
I appreciate that. The goal, though, I just want to confirm with everybody, is to complete this hearing today. And we will, of course, do our best to make that happen. So
Done my best, Judge, to give admonitions to if somebody, this could also be an over-exhaustive list. If one of the counsel I just named sees that it's covered, they may decline to speak. So
I appreciate that. There is at some point a hypothetical I wanted to present that anybody who was speaking could maybe help me with, but as soon as I have it written out here, as soon as I lay my hands on it, it may come as a surprise to all of you, but there's a lot of paper that's been filed. But as soon as I do, I'll let you know and give anybody who wants to respond to the hypothetical the opportunity to do so. But I'm going to let you move forward with the plan as you stated.
sounds good, Judge. We're going to start with Mr. Miller.
Good morning, Your Honor. May it please the court. My name is Brad Miller. I represent Doctors Michael and Kelly Ward. We're here to discuss the anti-SLAPP motion. And in our legislature's infinite wisdom, they saw some problems happening here in Arizona politics. And so they decided to address them, just like they do with any other law. And so in their wisdom, they decided to draft and redraft this anti-SLAPP statute for the purposes of determining full transparency of what is happening in prosecutions specifically. Now, one of the issues brought up by the Attorney General's office is this may be a violation of separation of powers. That couldn't be any less true. And the reason why is because the executive branch signed off on this particular statute after the legislature drafted the statute. And just like any other statute we deal with, for instance, like in sovereign immunity cases, the legislature and the executive branch can sign off and add powers or subtract powers or give rights and procedural rights to individuals at their will. In this particular case, a procedural right was given to individuals under certain circumstances. If there is a prima facie case, there may be a substantial motivation that that particular prosecution is seeking to stop or alter or deter the use of a constitutional right. Now, I want to get into really the meat of my presentation. And the meat of my presentation is really addressing the response by the Attorney General's office. And in the response, the Attorney General has chosen a methodology that we don't believe that this court should follow, because it does not follow with Arizona law. This past April, our Arizona Supreme Court, in a very, very important case here in Arizona, the Mays case, which dealt with Planned Parenthood. I believe it's Planned Parenthood versus Mays. They had to deal with multiple conflicting statutes after Roe versus Wade was overturned. And so they went into great detail on how a trial court, is to look and to analyze and to go through a statutory interpretation. We asked this court to look at that particular matter and see how the court defines on what the court's responsibilities are for statutory interpretation. And what this court will not find is that this court is to analogize from other cases in order to create principles of law to determine what prima facie means. And that's really my starting point. There are a lot of things that were adopted into our American jurisprudence that came over from the common law. The prima facie standard was one of those things. And it's a very simple phrase in Latin. Prima meaning first, and facie meaning face, at first sight, at first glance. It's a gateway into bringing a case. This court, I'm sure, has applied this standard that has been around for 500 to 600 years in multiple occasions, and especially here in this trial court, in front of juries, specifically in Batson challenges, where a moving party can move for a Batson challenge, and the standard is just prima facie. We see prima facie in not just criminal matters, but we see that prima facie standard in civil matters also. in a car accident case, a person wants to bring in punitive damages, the moving party is responsible to provide a prima facie case. And of course, in vindictive prosecution matters, First Amendment matters, 1983 matters. This standard is used all of the time. It is not a great standard. It, in fact, is a less standard, a very low standard, a gateway standard. But more importantly is this, is that prima facie has less to do with the burden of proof versus the burden of persuasion. Because prima facie, as used in our jurisprudence for 600 years, is used as an adverb or an adjective, not a noun. And that's important because it has to define what that standard of burden of persuasion is. And the burden of persuasion has to connect two things. And this is where I would like to address one of the court's questions yesterday regarding substantial motivation. How would a particular party prove or use that prima facie burden to determine a substantial motivation? Well, the way we do it is we bring forth evidence, and we connect those pieces of evidence in a reasonable likelihood. If that at first glance, that prima facie at first sight says that there's a reasonable likelihood that that piece of evidence, that affidavit, those facts at first glance are presented to show a substantial motivation in bringing a prosecution, then therefore the prima facie standard has been met. And we believe it has been met in this particular case. In that Planned Parenthood versus Mays case, the Arizona Supreme Court talks about how we conduct statutory interpretation. It says we first start out with reading the words, going to dictionaries, looking at common law phrases. And in paragraph 15, it says we interpret statutes in view of the entire context, considering the context and related statutes on the same subject, not different subjects. As I stated, and I started my remarks, the Arizona legislature in their infinite wisdom looked at what was happening politically, and they decided to create this anti-SLAPP statute. And the reason why is because they wanted full transparency of why certain prosecutions were occurring. Because if people don't have faith in our system, then our system falls. And the best way to do that is to bring things out into the open. And that's why we come to courts. That's why we come in here, so we can bring that information out. And maybe our Attorney General has a very good basis for bringing this particular prosecution. But at first glance, at prima facie, she does not. And therefore, we believe that we are entitled to question her, to seek out discovery, to determine what motivation she actually had. And those things are important. And we believe the facts are extremely telling. As we heard yesterday from the Deputy Attorney Generals, they believe that bringing a lawsuit or an appeal could therefore be criminal. That is absolutely abhorrent to our American jurisprudence. It's not correct. And in fact, we should believe in the opposite. We should believe that we and parties can bring cases under any circumstance to a court so that courts can decide things. We would rather cases and controversies be decided here in this room versus out there on the street. And that's why we bring cases. Now, within the context of an election challenge, it's even more difficult. As this court, I'm sure, is aware, under Title 16, a person does not even get a right to appeal an election or bring an election challenge until a canvass is completed. And then they're given 5 days to bring that challenge. That's not a lot of time to conduct discovery, look at evidence. There's not a lot of time. And so oftentimes, and this is where prima facie is extremely important, oftentimes they have to go on the information that they have. Statements made out into the media, statements in public policy decisions, or, and what's important in this case, what a person actually campaigns on. And our Attorney General campaigned, and you have all of this evidence in front of you. Our Attorney General campaigned to go after what she called the fake electors. Fake electors. She said she was going to prosecute these individuals. And she says it's already out there on tape what crimes that they committed. Those are public statements that she made over and over and over again, not just to various news organizations, but on Twitter and during campaign rallies.
Let me just pose a question for you. Isn't this true for any candidate running for a prosecutorial office? We hear lots of candidates talk about being tough on crime, and they sometimes get specific on specific areas. Is there the potential under this statute now that either candidates have to measure all their words, or any candidate that speaks what their intended policy will always be subject to this anti-SLAPP legislation because they campaigned on it? It seems like we're going to go in two extremes here. What is wrong about somebody running for office saying they believe a crime was committed? And one of the documents that was provided showed something from Attorney General Mays where she said the crime is actually videotaped. So she's not saying their fake elector behavior is videotaped. She identifies what she believes to have been a crime. Are you suggesting this legislation is now so wide-reaching that candidates are going to have their words used against them if elected to a position of prosecutorial authority?
No, I don't think the statute was meant to have a person's words be used against them. What the legislation's intent was is to have issues of transparency. So if it appears at first glance, prima facie, that it could be a political persecution to alter or to deter a constitutional right, then all the executive officer has to do is to now bring forth evidence, objective evidence that that is in fact not true, and meet each of those wickets. This is an attempt at bringing out into the public, showing our government and telling the people what our government is doing and why they're doing it. It's an attempt at transparency. It's an attempt at true democracy. And these are the things that we should be emphasizing. Bringing court cases, bringing appeals, being free to speak. And no, I do not believe that a candidate's words can be used against them, maybe politically. And we talk about, and this court asked the question regarding a person's speech out on the campaign trail. Well, certainly those words will be used. That's why they're asked those particular questions, what policy prescriptions they may have. But what they shouldn't be doing is commenting on a specific case on what they're going to be doing and what that motivation is, unless they want to answer for that. And we should expect that from our government officials. I don't care whether they're commenting on a specific matter or on a more general matter. We should want our political officials, anybody elected to office, to answer and to be able to answer into the public about why they're doing what they're doing for full transparency's sake.
Well, there were candidates running for office who were advocating for the prosecution of Hunter Biden, and he was then prosecuted. You said they can talk in general terms, but not when they get specific. Isn't it possible, I'm not suggesting Hunter Biden was involved in protected speech. I'm not getting into what his charges were. I'm just asking your comment was they could speak in general terms, but here they were talking about specific defendants. Yep. Why is there a distinction there about naming specific people that should be prosecuted?
There isn't a distinction. If a, let's say, for instance, we know Hunter Biden is likely a Democrat. If a Republican Attorney General ran on a platform that they're going to prosecute Hunter Biden, then I think the public earns and demands, because it's the people who rule, not our government officials. It's the people who rule. If the people demand an answer about why you're bringing this case, provide objective evidence about what this particular crime is, and then to provide evidence that this is not politically motivated, then they should demand that answer. And that's what the statute provides.
Am I correct in reading the statute, and it was actually argued that the purpose of the statute is not to determine guilt or innocence, and under this statute, people who might be guilty of a crime may otherwise not be prosecuted if the statute is met. Am I correct in that?
I believe that's how it's written. I guess we'll see how it gets fleshed out over time, but I believe that's what the statute holds.
So historically, and constitutionally, we've accepted that things like Fifth and Sixth Amendment violations and dismissal of charges against people who there's significant evidence to show they're otherwise guilty is fairly, even though the rights are embedded in our society and in our legal culture, it's extraordinary relief to dismiss a criminal case because of a constitutional violation. I asked the question yesterday, and I still don't know that I have a clear understanding. If that's extraordinary relief, here again, it's a constitutional principle, First Amendment rights, and dismissing a case against someone, and I'm not declaring it here, I'm saying anti-SLAPP can apply to people who are otherwise guilty, but they're entitled to the relief if substantially motivated by, and the rest of the statute. Why isn't that extraordinary relief and should be, even though the prima facie standard is set, why shouldn't we view it as extraordinary relief when there's already 12.9 protections, there's already probable cause protections, there's Rule 16.4 protections, as Mr. Willencheck argued yesterday. I'm trying to find a place for this statute in the context of how we deal with valuing constitutional rights over guilt or innocence.
Sure, I think we have to look at the backdrop of both. As I read to the court regarding the Arizona Supreme Court's statutory interpretation, we look at the context of the statute too. And as the court provided regarding at least a Fifth Amendment due process violation, it's actually the courts that carved out the prophylaxis rule regarding suppression. It wasn't a specific statute. So I think that's very important too. So the legislature and the executive branch saw an issue in this particular case for the anti-SLAPP statute and said, we need to address this.
So when the legislature did that, suppose somebody was protesting whatever the given issue is, and people became out of control and started looting. Was the legislature intending then to create an avenue for those people who were guilty of looting, that they now could go ahead and have the charges dismissed if they can show that whoever the party in power that these people were protesting, that it was motivated by really quashing their free speech?
Well, what the legislature, and I know the court keeps mentioning the legislature, but we have to remember the executive branch also signed off on this particular statute and gave.
The executive branch doesn't make the laws.
Sure.
It's the legislature, and I got an amicus brief from them explaining to me what the intent was, so I have to rely on that.
Absolutely. And so in that particular case, the legislature looked at these particular problems and said our protections and of our constitutional rights, our First Amendment rights, are so important. We're willing to allow people who may be guilty of these particular crimes to go free if the prosecution was motivated to deter and to stop or alter those particular constitutional rights.
So those who voted in favor of this legislation, if we took what happened around the country after George Floyd was killed, would they say that their intent was to cover potentially cases like that as well?
It goes back to that substantial motivation factor, Your Honor. It really does. If the purpose of prosecuting a George Floyd protester was purely political and not based upon objective, reasonable criminal activity, something that had been in the law consistently, had been applied evenly, then yes, those things should be dismissed. That's exactly what this procedure is for.
So that's what takes me to the hypothetical I wanted to pose, and I can't put my hands on it at the moment, but I will. It was in the amicus brief. There's legislation, and I'm not quoting it exactly, the hypothetical they put in, I didn't come up with it. The legislature is dealing with some issues that would increase involvement of law enforcement. There are people that were protesting that. A leader of law enforcement sends in extra patrols to say, keep an eye on everything, and with the goal of really having an impact on the exercise of the right to protest. And they watch somebody throw a rock through the window at the state legislature and arrest him. Under the hypothetical that was in the amicus brief, that person would be entitled to a dismissal. Why would that person be entitled to a dismissal in that circumstance? Or do you disagree with the amicus brief?
Again, I don't know all the facts of that particular case. I assume that's
Not a real case. It's a hypothetical.
sure. And we had a very similar case around that time regarding a breach of the Arizona Senate. So perhaps it's addressing some of those issues. But I think that we need to look at the particular facts of the case. Was that prosecution, and this is where I think maybe the hypothetical goes a little bit wrong, was the prosecution substantially motivated for the purposes of stopping First Amendment activity? Or can that prosecutor justify their charging decision based upon objective reasons, based upon the fair application of law, and based upon a law that had been charged consistently in that particular office? So unless they...
No, finish. I didn't mean to interrupt. I apologize.
Unless they can address those matters, then it should be dismissed. But in most cases, a prosecutor can look at those and say, and they should, for again, this is the purpose of the law is going back to full transparency of why prosecutions are occurring. The people are looking at their government right now and are very unhappy with it. Many of our elections are decided by very few votes. There was a recent congressional race that was just decided by less than 40 votes here a few weeks ago. So people are very upset and they want transparency from their government. They don't trust what's going on. So a prosecutor should desire and to want to justify the reasons why they brought that particular case. They shouldn't hide behind a probable cause hearing or a grand jury and say, well, they decided it, we didn't decide that, they're the ones that made the decision, not us. No, this law addresses that particular problem, saying we need transparency so bad that we want our prosecutors, our attorney general, to stand up in public and say why they did what they did. It's that important. We believe in the First Amendment so much, we believe in transparency so much that we want that. And I believe any good prosecutor or attorney general should want to provide that type of transparency to the public. That's exactly the purpose of the law.
Okay. Thank you.
So I want to talk a little bit about moving on. We discussed the separations of power issue. I don't believe there's any separation of power issue because this particular statute is a procedural right and just demands that the Attorney General answers some questions in the public to provide full transparency. Now, the Attorney General in their response provided a couple of analogous types of cases, none of which apply. And the reason why they don't apply is because in a selective prosecution, vindictive prosecution, or retaliatory arrest type of prosecution cases, we're dealing with 1983 claims, we're dealing with equal protection types of claims. All of those claims are analyzed within the philosophy or the purview of a tort, which require elements of causation and injury. So they needed to provide a prima facie case regarding those particular elements. That is completely different than the statute that we're dealing with in 12751. This particular statute is more akin to analyzing a case under a criminal purview or a criminal philosophy, where we look at mens rea and actus reus. And that mens rea is that substantial motivation factor. That actus reus is very much like that constitutional violation factor. We want to look into the mind of why the prosecution brought this case. Wants a prima facie evidence, proof. And that can come from affidavits, that can come from public statements, Twitter posts, all of those things. Once that low bar standard is met, we need to look into why this particular matter is brought. And then the Attorney General just has to answer some questions. That does not require a dismissal. And I think maybe in the amicus, that hypothetical got ahead of itself, that the case should be dismissed. Remember, there's an opportunity for a hearing. There's an opportunity for a judge to examine the facts. There's an opportunity for people to be questioned. That prosecutor can provide an affidavit as to why they brought that prosecution of a person throwing a rock through that building. And then the judge will decide in the reasonable place where it should be decided here in this court. And that's all we're asking for, is an opportunity for transparency. And we believe that we're entitled to that. Going back to the issue of statutory construction, we ask that this court follow the rules of statutory construction as laid out by our Arizona Supreme Court, and that has been enshrined in our common law for hundreds and hundreds of years. And that requires an analysis of the context, what the statute says, and if a word is in fact not defined in that statute, we look to dictionaries and we look to other uses of that word, how it's applied. The Attorney General, in their response, did not apply the prima facie standard appropriately. They confused the prima facie standard with the elements required under an equal protection claim. If you actually look at the prima facie standard in some of the cases that they cited, some of those cases they actually met the prima facie standard. And it was more an issue regarding whether there was proof provided of those elements. Let me give the court one example. There was a particular example regarding a tort matter regarding punitive damages. And the court essentially said that there was no prima facie proof, and the attorneys just provided conclusory information regarding whether punitive damages were allowed. And in that case, if it's just conclusory, then the prima facie standard is not met. But if there's proof, if there's evidence, if there's an affidavit, a person's own statements or own words, in the hypothetical this court posed, if that prosecutor prior to charging that individual says, if a person throws a rock through this and they claim to be an independent, I'm going to prosecute them. Or they said, I know some of my political opponents are out on that road throwing rocks at the Senate building. I intend to go after them. Then the public in this court should demand an answer from that prosecutor, that in fact they have an objective basis for bringing that claim.
So if somebody campaigned on the notion of, we need to go after all the rock throwers who have been throwing rocks at our legislative institutions and buildings, throwing a rock at a building is a crime. It's dangerous to the public and to, that nobody would support the idea that you can throw rocks at anything. You're saying that if somebody campaigned, I'm going to go after all the rock throwers, that person would then have the right under the anti-SLAPP statute to force the prosecutor to explain why they're upholding the law?
Absolutely not, Your Honor. And the reason why is because there's no constitutional right to throw a rock through a building.
But they were exercising their free speech. They were protesting what the legislature did, and they were throwing rocks to make their point. You said, I thought you raised it, maybe I misheard you, about an example involving rock throwers.
Yeah, so the issue would be is that whether throwing rocks through a building is protected speech. And I believe under our U.S. constitutional analysis and understanding of speech, our understanding of Arizona law, that it is not protected speech.
Okay, we agree, it's not. So what if some other act, instead of rock throwing, I'll use this, it was, I'm not saying this occurred here, but the allegation here that there were fraudulent documents submitted, that's not protected speech either. Fraud is not protected.
Correct.
Forgery is not protected. Why is that different than the rock throwers? Where is that an exercise of free speech, but throwing the rock is not?
The issue would be the conclusory nature of saying that these particular documents are fraudulent. The analysis goes back to step one. This is where I think this whole case is getting confused. We need to start at step one. What is the actual analysis that we're working through? Just like the statutory construction. Our Attorney General in the response immediately went to analogy. That is not the right step. The right step is to look at the context of the statute and march through the statute slowly and through reason and look through what our statutory analysis is.
And that's what the amicus brief I thought was there to help. And they're the ones that provided this. Are you saying I shouldn't rely on that part?
I'm not necessarily saying that. Again, I don't know exactly what the court is addressing, but I will say this, is that we need to look and start with the steps. What are the particular steps? And the steps for the prima facie case, we need to look at statutory analysis and 500 years worth of precedent on how that standard is applied. And we know that it's a low standard. Secondly, we need to look at whether this is constitutional protected activity. Is filing an appeal a constitutionally protected activity? And it absolutely is. Is redress of grievances part of that process? Yes, absolutely it is. Is asking for your, is filing a lawsuit in an election challenge constitutionally protected activity? Absolutely. We have a statute on point saying that we can bring cases and controversies to the court. This is where we should want them to be. And remember, because of the timelines in Title 16 are so tight, oftentimes cases are brought without being fully developed, like many civil cases. And in this case, the case was brought legally, challenges were brought, they were still pending in our courts here in Arizona, and there was precedent, at least according to my clients, and I can read a statement from my clients. We talked a lot about motivation, of why my clients did what they did. But they were very open. They not only put it on video, but they brought a statement. And their statement said specifically this, and my client read this prior to the signing of that particular day that you, I'm sure, have seen on the video.
I haven't seen the video.
Well, you do have the video in your packet, Your Honor. But they said this: the legitimacy and good sense of two sets of electors meeting on December 14th to cast competing votes for president and vice president with the conflict to be later sorted out by the courts and Congress was pointed out by prominent Democrat lawyers Van Jones and Larry Lessig in an essay published last month in CNN. Given that the results in Arizona remain in doubt, with legal arguments still to be decided, just as the Democrat electors met in Hawaii in 1960 while awaiting a final resolution of the state's vote, so too the Republican electors have agreed to meet this year on December 14th as we await a final resolution of Arizona's 11 electoral votes. That was a public statement. So we want to go to intent. We want to talk about what they actually did. We want to talk about whether it be constitutionally protected activity. The court has that evidence. But remember, the standard is still a prima facie evidence that there is a substantial motivation by the Attorney General, and that the constitutional activity, just prima facie evidence that the constitutional activity could be, we believe that it is, but could be protected. And we believe that any appeal, any redress of grievance, any bringing up to a senator of First Amendment activity is protected. And therefore, we desire and demand a hearing from this court, and we ask for a hearing from this court, so that we can put it out into the open, into the public, that we have full, transparent cases going in front of our courts, and that people are not prosecuted improperly.
Going back to prima facie, the case of Virginia versus Black, 538 U.S. 343, it provides a definition which resonated for me, and I want to see if you feel it's appropriate. The burden is applied here is that the showing is sufficient to establish the claim, and which, if not rebutted or contradicted, is sufficient to sustain the dismissal. Would you say that's a fair definition?
I do, Your Honor. I believe that's, we see that in Arizona law also, and in other state laws. In researching the issue of prima facie, I looked at many other Supreme Court rulings on this particular matter, and I believe that's consistent.
Now, if the prima facie standard is met, one of the burdens on the state is to show that they have the different ways for them to rebut the showing. One of them includes consistent treatment in other situations. As we've all had here as a discussion, I've only heard of 3 clearly identified situations where this happened with electors. 1870-something, 76, I think, if I'm not mistaken, somewhere around there, 1960, and now. What about the notion that there are, do they have to show they've prosecuted other people for fraud who filed false documents? Or do they have to go further and get into what they've done with people who have allegedly committed political fraud, I'll call it, as opposed to financial fraud.
Sure. And 2000 Bush v. Gore was another electors case. There were dueling electors in that particular case also. But to address the court's question, that depends on how the state wants to prove that they did not act for a political motivation, that their decision to charge that case was not substantially political, not substantially motivated by politics. And so I think that goes back to the state, how it wants to prove its burden. I think if we were to tell the state how it is to prove its burden, we could potentially be stepping on separations of powers issues. And we saw that in some of the cases cited by the Attorney General's office, especially in the First Amendment context and in the charging decisions. There was one particular matter that was remanded, or I'm sorry, that was, I think went to appeal, remanded, and it was brought back up. And instead, the state decided to charge, to heighten the charge, add additional charges to this particular matter. And in that case, the court essentially said, well, we're not going to get into the reasoning on why because of separations of powers issues. But in this particular case, under the anti-SLAPP statute, what we're asking for is for the Attorney General to tell us why. Give us a good justification, be fully transparent of why you did what you did, so that the public knows that the Attorney General's office is run appropriately with fair and just results. That's all we're asking for. An opportunity to be heard, an opportunity to question. Thank you very much, Your Honor, unless you have any additional questions.
No, I appreciate your comments. Thank you.
Markentel for Senator Kern. I think that we'll go to Mr. Jacobs, who's appearing virtually.
All right. Mr. Jacobs, are you, I'm not seeing you, but I see you on the screen.
I think you don't want to see me because if I show you a flash of where I am, you're going to wish you were there. But I do appreciate the courtesy of the court allowing me to appear by teams for the second day of the hearing.
We could,
I will try.
We could, if you'd like, though, we could delay the hearing and meet you wherever you are.
I'll show. I would show you a picture if I get this camera to work there. Let's see if I can give you something here. There you go.
All right, I think you're right.
Yeah, so I'll turn that off. Your Honor, I'm going to attempt to stay in my lane as much as possible with regard to the information that we're going to be covering today. And I'll confess that at times when Brad was up there, I was sort of jumping up and down saying, say this, and he always got to it. So there's a lot that I will not repeat. But what I did want to say with regard to the prima facie standard is just this. And Brad covered this by noting that it's about lawful exercise of constitutional right. But, you know, prima facie is, in this context, if it appears that by their criminal action, the state is trying to deter, retaliate against, or prevent, in other words, stop people from doing something again, and what they're trying to prevent is lawful constitutional activity, then that's a prima facie showing. What I'm going to talk about is the glaring example, and it's obviously self-serving to my client because she presents, with respect to the case against her, a really good example of why you should find that there is a prima facie case for trying to stop her from doing things that she was doing, which admittedly was very little, but all of which was lawful and constitutional. I would note that with regard to Ms. Bobb, by comparison to other people who were not indicted but who were mentioned in the indictment, there were about a dozen people, including Dennis and Jack Willencheck, Lee Miller, Aaron Green, Josh Offenhartz, who testified in front of the grand jury and was closely cross-examined by grand jurors, Josh Finley, Kelly Townsend, Tom Lane, and Jana Ellis, whose involvement in this was little to none and who was dismissed by the prosecutors recently, and who then went to the media and said immediately, I didn't actually do anything and I don't know anything. Christina Bobb had even less involvement in these activities than Jana Ellis, who was just recently dismissed. My observation in reading the grand jury transcript, and this is about the grand jury's interaction with the witnesses and the attorney general's involvement and reaction to those dialogues on the record, and about how it shows that at times during the grand jury proceeding, the grand jury indicated that they didn't really understand why Ms. Bobb was even in there, and the attorney general did nothing to stop its witness from attempting to bolster that opinion with conclusory statements. And I will give you specific examples. So to begin with, at the beginning of the grand jury proceedings on the 16th of January, and this would be part 2 of that transcript, page 30 for reference, and I believe these are attached to our motion. During the relevant events, it was testified to that Ms. Bobb was in fact a reporter for One News Network, One America News, and a volunteer for Mr. Giuliani's office. That's how she was sort of introduced to the grand jury. The second mention of Ms. Bobb, and I go through these individual mentions because there's only a handful of them. December 8th, 2020 email from Jack Willencheck to Boris Epstein with the Chesborough memo attached, outlining the Arizona GOP alternate elector plan, and that's Exhibit 3 to my reply, and that was on January 29th, that was mentioned in front of the grand jury on page 24 of that transcript. Ms. Bobb was included as a CC to what the state's witness, Detective Ignowski, referred to as quote unquote local people with no further details. Following the initial discussion of the December 8th email in the grand jury, and in the actual email itself, Ms. Bobb was not mentioned as a continuing party in that email chain, nor was it alleged or obvious at all that she contributed in any way to the discussion. She was a CC on an email outlining the plan. Ms. Bobb is next mentioned the same day, same transcript, 12924, on page 42, during Josh Offenhartz's testimony when he was asked what Christina Bobb's role was, and he said it was, quote, represented to him, unquote, that Christina Bobb may or may not be an attorney, and that she was a, quote, super supporter and activist, and someone who would have had a connection to the campaign, but not the DC or the White House side of things, unquote. And that's page 42, and that's from Josh Offenhartz, who was an attorney working on these lawsuits. Days later in testimony, taking us all the way out to March 4th, Detective Ignowski again mentions Christina Bobb as having posted on a social media site, Twitter, in response to a post by Kelly Ward expressing an opinion, Ms. Bobb expressing an opinion about Rusty Bowers, misleading the people of Arizona, trying to avoid declaring Trump the winner. Again, this was an absolute and unabashed opinion offered on Twitter in response to someone else's comment. And this is part of the state's evidence that they put in the indictment, mentioned in the indictment, and put in front of the grand jury, indicating very clearly that this is something that they were targeting. This is some conduct that they felt was wrong or criminal. By March, and this is 2 months into the investigation, the grand jury had heard so little about Christina Bobb that they apparently forgot who she was and asked Detective Ignowski to remind them. And again, the Attorney General obviously is present in conducting these proceedings. Detective Ignowski stated she was a former reporter turned like advisor for the Trump office. And that's a quote from page 185 of the March 4th transcript, also attached to our reply. And this is rather key here. When one of the grand jurors asked whether Christina came to Arizona, quote, with the expressed intent with trying to get electors to get the governor to change their vote, unquote. And this was a direct question from the grand juror asking, first of all, whether it was correct that Christina Bobb came to Arizona, and she did not. She was not physically in Arizona during that period of time. And whether she came here with a specific intent to try to get electors to get the governor to change their vote. And this is page 186 of the March 4th transcript. Detective Ignowski's response in front of the grand jury, and not in any way corrected by the Attorney General, by any member of the Attorney General there, was, quote, she was in deep with this whole scheme, period, end quote. That's it. And the juror said, thank you. And there was no follow-up on that. In other words, the grand jury at this point, and it gets better, the grand jury wasn't really sure what her involvement was. And it was an absolute bald-faced lie that she came to Arizona. She was, in fact, back east with COVID. And if this goes to an evidentiary hearing, when it does, she will certainly bring those medical records to demonstrate that. The fact is, Detective Ignowski did not know, and he answered by going around the grand juror's direct question and giving a general answer that was conclusory and not evidentiary. I mean, not only was the response not a yes or no, but it was conclusory opinion based on no facts presented to the grand jury or known to the investigating officer. Regardless of whether the Attorney General believed that the elector plan was legal electioneering or not, there was then and there is now no evidence that Christina Bobb agreed to participate in it, actually did participate, or otherwise assisted the elector plan, but they wanted to indict her anyway. And there has to be, where there's a complete lack of evidence, there's got to be something else going on, and that's the prima facie. That's where you get to almost what we would call the res ipsa loquitur standard, which is it speaks for itself. There's something else going on. Why do they want to get her? Because she's a One America News reporter, because she said unfavorable things on Twitter. Part of their evidence was even a report that she gave on One America News. They actually concluded that in their evidence. A reporter reporting on a story, and also a New York Times article talking about things that Christina Bobb had said. Despite assuring Ms. Bobb, and this was another thing, she was assured in writing when solicited with a subpoena in Florida, when she was in Florida, the Attorney General came to serve her with a subpoena that had not been domesticated. It was for all practical purposes a, quote, fake, unquote, subpoena. It was an ineffectual document being served on her to testify in front of the grand jury, a subpoena that had no legal binding effect whatsoever, and the AG knew that. And during the transcripts of the discussions with the grand jury, the Attorney General advised that they planned to have her testify on March 18th. And in fact, that there was a discussion about serving her with a domesticated subpoena, which they did not do. Ms. Bobb would ask me to mention, hey, that's a fake document too. But I think it just stands for itself. They sent a letter with it that said, please come testify. You've been asked to testify and provided a subpoena. You are not a target of the investigation, period. At the time, in fact, Ms. Bobb was a target of the investigation. There had been discussions about her. There had been pointed questions from the grand jury ahead of this time, trying to place her involvement before the Attorney General reassured the grand jury that she was in fact going to be testifying while simultaneously assuring Ms. Bobb that she was not a target. Ms. Bobb did decline to testify because the subpoena was not binding, and obviously she did not have the need to do that. There is a discussion on the 18th of March, so now we're moving farther from the 4th, when they're asking what her involvement was and what her intent was, and the detective is refusing to answer. On the 18th of March, and this is on page 46, 47 of the transcript, there is an attempt by the grand jurors to categorize the people who they felt were going to be targeted by the investigation. And this is really also critical. And they broke them into three categories, Your Honor. And the grand juror states the following. The third sheet that you see are unknowns. They are people we have a couple of targets on there. There are people that have come up in testimonies that we will likely ask more questions about, just so that we can solidify in our minds what role, if any, they played in this process. Mr. Klingerman, moving on to the third sheet. These are the unknowns I was assuming for potential follow-up. And the following list is then read: Rona McDaniel, Christine Ferreira, several others, including Mike Aaron Green and some others I've mentioned. And lastly, it says Christina Bobb is listed as a target, quote unquote. Is that a correct summary of the sheet? And then they go to move to the fourth one. At the end of this conversation on page, and this is going to page 54, after they've identified her and some others as possible targets, the following discussion occurred where one grand juror attempted to frame the case by presenting an analogy to a murder conspiracy in which there were three circles of actors: a person of power who conceived the goal, people who provided the means to execute the plan, and the people who acted to execute it. The juror was even then still unable to place Christina Bobb in any role. And keep in mind, this is over 2 months into the investigation and a month before the indictment actually was signed. The grand juror states, with regard to people who might fit in that third category, potentially Roman, who was employed by the campaign to help to execute this purpose and power, maybe Biggs and Gosar in the sense they occupy positions of power and help to really push that toward achieving the larger purpose, and understanding neither of them was indicted. And finally, and maybe even Christina Bobb. And keep in mind, this was at the end of the categories. This was the catch-all omnibus category. And the juror says, quote, "I just threw her name up there. I didn't know where else to put her for now. Period. That is the larger circle," unquote. And that's page 54 of the March 18th transcript. No response from Mr. Klingerman or the AG's office with regard to that. But instead, the Attorney General next tries to bolster its case by trying to sort of leverage Christina Bobb's, their case against her, by trying to allege involvement through the mention of her name in a text message Jason Miller sent to Boris Epstein. And this was a discussion that Mr. Klingerman had with Detective Ignowski, asking about Boris Epstein. And Detective Ignowski acknowledged that, okay, we're talking in a paragraph about Boris Epstein. And they talked about a text message that was sent. The response from the detective about what it was is he said, so Boris was reaching out to state electors or the state elector in all of the 7 contested states. He was making sure that the right people were in the right place and basically contacting states. And in our case, it would be Kelly Ward he reached out to. Question. And so also Jason, parenthesis, Miller is telling the 3 others on the text message thread that they could connect with him and Christina Bobb. That's right. Again, the fact that she is mentioned in there is somehow significant to the Attorney General, but constitutes no evidence. The AG on page 81 of that March 18th day attempted to establish that she had played at least some role in the plan. And reminding the court, I'm not trying to argue a Rule 16 here or a 12-9. I'm trying to highlight that there was so little evidence that there had to be another motivation. To show she had some role in the plan, the AG tried to note that she was listed as a participant in a conference call at which the electors' plan was discussed, and that's presumably the December 8th conference call. And the list of participants allegedly included Rudy Giuliani's putative girlfriend, Maria Ryan, as well. There were a number of people who were on that conference call who never spoke and had no role, Christina Bobb among them. The AG does not like her in the sense of that call because she provided to her supervisor a summary of what was said in the call. She participated not at all. She said nothing. She had no involvement in the planning or discussions whatsoever. So the next day after that conference call, Jason Miller and some others, and this gets forward to December as far as the activities. The conference call was the 8th. Actually, I think it was the 12th, but very close after. There was a discussion about possible public statement about the electors' plan. In other words, what the planners would say to the public about what they were trying to do. And Jason Miller suggested they ask Christina Oann, which is O-A-N-N, presumed to be Christina Bobb, because that's One American News Network. Again, a reference to her with absolutely no follow-up details, no conduct, nothing that she did or was even asked to do. Finally, on December 9th, there was an email from Boris Epstein to Jim Tropas, who was working, and Jim was working with Ken Chesborough on the legal analysis, because as has been mentioned, there was a close legal analysis by Mr. Chesborough and others to look at the precedents, look at the law, and determine, just confirm that what they were doing was in fact not unlawful, because it had been done before and it was not unlawful. And there was some reference to asking if someone could prepare some ballots, form of ballot for Arizona, and the request was neither assigned to nor specifically directed to Christina, but it was implied that it was. She took no action on it, and in fact, it was Tropas who drafted the certificates. The Attorney General here is trying to get her for guilt by association with people who actually did things. If you take that all of this back, and that's all on the facts really. If you take that back to that grand juror's question on March 18th, what are we doing with Christina Bobb? Where are we putting her? I don't even know where else to put her. We see that she was someone who was so out of the loop on this thing, so uninvolved, that the grand jury, after 2 months of testimony, could not decide where to place her in a broad organizational structure. At the same time, she was someone who, there was, I think, a Twitter post saying that she was with Rudy in Washington trying to get Congress to accept electors. In other words, she was lobbying Congress. She was engaged in lawful First Amendment electioneering activity. And this is part of their evidence against Christina Bobb. She was also a reporter saying unflattering things about the Arizona election. And before this indictment was even sought, she'd already written a book called Stealing Your Vote, which is about the Arizona election and her opinion that the Arizona election was not valid, that it was not properly done, and that the vote should have gone the other way. These are her opinions, but they have been boldly stated. Also, sort of following right with this indictment and right before it, Christina was also appointed to be the RNC, Republican National Convention and Committee Advisor on Election Integrity. I'm not sure what that position entails, but it sounds important and it sounds political. And she's clearly a political person who has been working for the Trump campaign for some time. And these are events that upon which the indictment of Ms. Bobb and even mention of her in January of 2024 follow close on the heels of. So this is what I think many of my colleagues, and I should just pause to note that I do feel very privileged to be in the presence of these folks who I have no doubt know more about the law on this than I do, but I'm learning a lot. I appreciate all the comments of counsel, but this is just an example of prima facie evidence, prima facie showing that based on the indictment alone and the grand information in the grand jury transcript and the evidence provided to support the case against Christina Bobb, the only possible motivation, and certainly on its face, Your Honor, on its face, there is a showing, a prima facie showing of an improper motivation to try to keep her from saying bad things about the Arizona election, lobbying Congress, participating in the Trump campaign, doing these things that they didn't like she was doing. If she had been someone else, like one of the people who wasn't indicted, Your Honor, she wouldn't have been indicted if she didn't have this profile. There's no other explanation for it. And Your Honor, with that, I will ask if the court has any questions, and otherwise I will pass the stand to the next speaker.
So just, and you confirmed this in your comments, the same arguments, you're saying the arguments that could go to a 12.9 motion as to the sufficiency of the evidence, you're saying here, because the evidence was so lacking, it also supports that there was some other motive in bringing the charge. Am I hearing that correctly?
Almost. A 12.9 motion that we will file will target the manner of the proceeding, the unfair presentation, because challenging sufficiency of the evidence in a grand jury proceeding, that's not really what I'm saying here. I'm saying that yes, there was insufficient evidence and that the grand jury shouldn't have indicted her. But I'm also saying that the state had ulterior motive to get them to indict her, as is reflected in the fact that their detective about 3 times expressed conclusory opinions in response to direct questions by grand jurors, trying to involve Christina to make sure that they would indict her. And notably, there were 3 grand jurors who voted no bill on this. To take this case to trial with some record like that, I've done this for 34 years. And frankly, I don't think I've ever seen a good trial result for the state on a case like this where 3 grand jurors wouldn't even come up with a bill. But that being said, they should have on this evidence just put her in the same category as other people and who were not indicted and said, look, just we're pulling her name, or done the right thing, which is to dismiss her now or before this, like they did with Jenna Ellis, because she shouldn't be here. And this is destroying her life. It is denying her a security clearance. It is everything the SLAPP statute seeks to prevent. And the last comment I'll make just in response is the SLAPP statute isn't just another law. It's the type of law we already have with prosecutorial conduct or misconduct or selective prosecution, but it's aimed at First Amendment protections, it's aimed at constitutional protections, and it has teeth in it. You can seek, and this is somewhat unprecedented, you can seek attorney's fees from the state if the court finds ultimately that this was an improper action and dismisses it. It doesn't say you have to grant them. But as someone who has spent tens of thousands of dollars on her defense to date, I would say that Christina Bobb would be in the category of people who would be trying to recoup some of that money. But absolutely, we have made a prima facie showing here, Your Honor.
Thank you, sir.
Thank you very much for your time.
Mike Bailey on behalf of Boris Epstein Stein. So, Your Honor, I'd like to, I guess, start out with what I'm thinking of as housekeeping, but try to just run through some answers on behalf of Mr. Epstein, some of the questions the court has raised. So I apologize if this gets tedious. To any degree it does. The court asked yesterday about the meaning of substantially motivated. And so I did some looking last night to try to find out if I could offer the court any help on that. Sadly, there's no, the phrase appears in the Arizona cases, I think 3 times, but it is not at issue in any of those occasions. So went looking elsewhere. Black's Law Dictionary, a couple out of there to start with. Substantial factor test. The principle that a causation exists when the defendant's conduct is important or a significant contributor to injuries. Substantially justified. Sorry, that's actually not helpful. A substantial evidence rule, here's a definition, and then there are also some cases on that. The principle that a reviewing court should uphold an administrative body's ruling if it is supported by evidence on which the administrative body could reasonably base its decision. And clearly, I mean, there are a full page, more than a page of substantial use definitions in the law dictionary. There are also a number of cases that touch on it. 624 F Sup 3rd 1069, talking about the substantial evidence standard. This is a broad Ninth Circuit standard, and it's also used elsewhere in the country. There are no Arizona citations to it. An agency's decision satisfies the substantial evidence standard if it is supported by such relevant evidence that a reasonable mind might accept as adequate to support the conclusion. The standard requires more than a mere scintilla, but less than a preponderance of the evidence. Just pointing out now an Arizona case that while it doesn't address the term, clearly implies that as an evidentiary use, it does not rise to what could be a main or primary contributing factor. This is from, just a quotation from Coker v. DOR 206 Arizona 480, starting at paragraph 9. And they're talking, it's the court talking about the standard of review. A finding of fact is not clearly erroneous if substantial evidence supports it, even if substantial conflicting evidence exists. Clearly implying that there can be substantial evidence of 2 different things that are opposed to one another. Also indicating that it's not suggesting that a primary motivation in this case. Again, agency review, this is TWT Acquisitions. It's just a Lexus case, 2022 Tennessee App, Lexus 71, 2022 Westlaw 554312. We review an agency's finding of fact under the substantial and material evidence rule. Substantial and material evidence is such relevant evidence as a reasonable mind might accept to support a rational conclusion, and such as to furnish a reasonably sound basis for the action under consideration. Now, finally, a couple jury instructions that actually do talk about substantial motivating factors. These are in the context of employment discrimination. Judicial Council of California civil jury instructions, October 2023, November 2023, and this is instruction 2507, substantial motivating reason explained. A substantial motivating reason is a reason that actually contributed to the action. It must be more than a remote or trivial reason. It does not have to be the only reason motivating the action. And finally, Washington Civil Jury Instruction, WPI 330.01.01, employment discrimination, general disparate treatment, burden of proof. Substantial factor means a significant motivating factor in bringing about the employer's decision. Substantial factor does not mean the only factor or the main factor in the challenged act or decision. And then it goes on with some alternatives depending on the case. Dictionaries, frankly, or the non-law dictionaries are a little bit scattered. I'll read you the definition of substantial from Merriam-Webster. Consisting of or relating to substance, more relevantly, not imaginary or illusory. There are others. So agree that the court has some work to do figuring out exactly how to interpret it, but you have some examples of usage in the courts across the country, and of course, you can determine your own plain meaning, but I would only argue that it's not suggesting that there's a requirement that it be the main or primary factor, but it be a factor. Want to address the question you raised a little bit ago about politicians campaigning on the question of prosecuting someone. And, you know, we need to study, any politician can campaign on anything. It is rare, I think, for a potential prosecutor, somebody who's running for prosecutor, to campaign on prosecuting a specific defendant or set of defendants. In fact, we might say, I'm going to cut down on rock throwing or vandalism. That's my #1 priority. But to identify and specify a group or a case is not common, and it actually potentially puts the prosecutor at odds with the ethical rules. This is our ethical rule. It's a 3.8, special responsibilities of a prosecutor, subsection F. Except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees of other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 or this rule. The point is, it is very rare and raises ethics issues for a prosecutor to speak publicly about a specific case. The ethics issues aren't, I don't think, especially directly pertinent as an ethical question on our anti-SLAPP motion. But it does answer the court's question of is that a common practice, I hope. Also wanted to make a comment on your question about throwing a rock at the building and whether that's something that falls under the statute. And it's it depends. I mean, the defendants have a burden to show, at least at a prima facie level, that was the motivation, that the constitutional action was the motivation. So saying I'm going to prosecute vandals provides no evidence that the prosecutor has motivation to attack constitutional rights or to limit constitutional rights in any way. If, on the other hand, the prosecutor said, we can't have people wanting to abolish the police and then filing an action for vandalism, that at least maybe creates an appearance that it was motivated by a constitutional right concern.
I think the statute also require, I talked about it yesterday, the word involved, which the amicus brief makes clear is one of the standards. I'm trying to wrap my head around the difference between being, and let me preface this. Everybody is going about this motion as a group, which I understand needs to be done because everybody feels or is taking the same position. They're being prosecuted because it's substantially motivated for these to either retaliate against or restrain free speech. That's what the claim is. But different people are charged with different things. And if you have a group of people charged and one threw a rock, that person is differently situated than the one who didn't throw the rock. There's an act that was committed. And here there are some people, I haven't gone through the analysis of each charge against each person, but some, at least on the conspiracy, is based on some of the things that have been brought up here, where others actually are alleged to have committed an affirmative act. I'm just trying to get that distinction. When using the word involved, as the amicus brief tells me, is a factor. Does it involve free speech if you're throwing a rock, or maybe it does if you threw the rock as part of your expression? Do you follow?
I do, I think, Your Honor, and I think my answer is I disagree to an extent, perhaps, with your assessment that everybody is charged with different things. As a legal matter, and I think that's what we're talking about, the indictment charges all 16 defendants with the exact same offenses, either as conspirators or accomplices to the other acts.
I didn't mean different charges, I meant different behaviors that support the charges.
Different behavior. But because of the way it's charged, each defendant stands in the shoes, as of now, of each of the other defendants for the purposes of this motion. Certainly being prosecuted for, Mr. Epstein's being prosecuted for falsely claiming to be an elector as an accomplice. And so, again, I mean, I think that's as a legal matter, but the whole thing fits into the statute. And I guess if the court has any specific questions that I'm missing on that, when I say the whole thing.
I appreciate your point about accomplice liability and conspiracy and being any act is attributed to all the participants. I'm not making that distinction. But there are charges for filing a fraudulent document. And while the others are brought in, there's only 11 people that signed that. That charge could stand on its own if it were the only people charged. Am I correct on that? I mean, that's a separate offense that is being lumped,
Sure.
being applied to everybody else if they were all part of a conspiracy. But as an act, it's a separate act that, like the rock thrower, I'm not comparing a rock throwing to signing it, but I'm saying there's an actual act. You signed this and it said X and X was not true. That's for those 11 people. The others are being brought in on that because there's an allegation that this was part of a master plan or master conspiracy to impact the election. I'm talking about the act part for now. Your client is not one of the 11. If he were one of the 11, there's a specific act that is alleged, which is signing this false document. Does signing the document involve the exercise of free speech? Like does the rock involve the exercise of free speech? I'm just trying to distinguish between, like I just heard from Ms. Bob's attorney, that they're quoting all these comments that she made to bring her into this. There isn't an act that he mentioned like signing an allegedly false document. Does involve mean whatever you do that arises from exercise of free speech, or if what you're charged with is the free speech? And the example I can give you is just on the news yesterday of the person who spoke out at the surprise city council meeting and was arrested right there, told because she was commenting upon a specific individual, and they said that's not proper for here, and she got charged with apparently trespassing, is what at least the news report said. One could easily say, wow, that is involving your free speech. She's speaking, she spoke about something that they apparently had a rule you're not allowed to talk about. They told her to stop, she wouldn't stop, and they went forward. But if she had gone ahead and thrown a bottle at the chair of the city council, would that be involved in free speech? Do you follow I'm making the distinction? And I don't know whether it is a distinction. I'm trying to figure that out.
And of course, the bottle example makes it easier. And I think, again, in the context that the question only matters in the context of our prima facie burden and the overall analysis at stage 2. And so I guess I say maybe, and I apologize to the court for not coming up with a better answer than that, but we go through the two-stage analysis and see what is there. You know, one of the things with rock throwing and bottle throwing is prosecutors prosecute that all the time. That's one of the stage 2 factors. It's a lot harder to say this was directed at speech or the exercise of constitutional rights or something involved in the exercise of constitutional rights where it's the ordinary. That's one of the arguments I'll make, is that this case is very, very, very far from ordinary.
See, this is where the amicus brief has really caused more confusion than it did answers, because it's their example. And I concluded that they were in a unique position to comment on the policy, and it's their example about the rock throwing. It's not something I came up with or the state came up with. It supports they filed it to help me understand what the legislative intent was. And then they said rock throwing would be an example of something that would be dismissed. And I look at it and go, rock throwing does not involve free speech. You may have been exercising your free speech, but throwing a rock isn't part of it. It's not protected speech.
I
That's
think
where the problem is, and I don't mean to be imposing it on all of you, because none of you submitted that, but they submitted it, and some of you supported.
I'm taking that to mean it can be, depending on the circumstances of the analysis. It certainly is associated with the same process in the example, and so I'm not, coming up with an argument right now to say, here's the clear connection, but it's hard to do in the vacuum without knowing the other factors that we consider. But let me, by all means, I wanted to note during the course of this, will express some disagreement with what some of my colleagues have said. I mean, no disrespect to them in any way, but I will also defer to a colleague who I know doesn't want to speak to you, Kurt Altman, who was also in on the drafting of the statute. So I welcome Kurt to answer that question better than I did later on. I think part of my hesitation is I think there's value in the point the amicus is making. I don't think we need to get there in this case. If anything, it's incorporating, potential forgeries, which may or may not be speech, into, depending on the circumstances, into what in this case I think is the clearest, straightforward exercise of speech, which is the ability to make arguments to you as a judge, to our state legislature, to the US Congress, to our congressman, to the vice president, of something that you believe. And that's clearly what's being prosecuted at the core of this case, is making an argument to people, maybe other than the courts, that we think there was fraud in this election. I mean, that's the core issue. And so I'm a little less concerned about things that we're involved in. I don't really, I mean, I'm not giving you a good answer on the forgery, but I don't think it matters because clearly the certificates were part of that effort to be able to take an argument to the government, to get redress directly from the government. Also, as I save this for later, I want to go ahead and point out, we haven't done our Rule 16 motion yet, we will. But these actually aren't forgeries, what they're suggesting. In order for them to be an actual criminal forgery that meets the definition of the statute, which requires fraud and therefore materiality, the electors would have had to say, not only are we the duly elected and certified electors, but we are the duly elected electors who are those that are certified by Governor Ducey and Secretary Hobbs, and then show up at Washington D.C. and what are you Democrats doing here? We're the certified electors. That was never part of what. That's the only materiality that makes a difference to this case on the forgery charges. And Mr. Klingerman stood up yesterday and pointed out, in response to his argument to Mr. Willencheck, that the big deal about the forgeries was they omitted the contingent language that one other state had used in their certificates. Absolutely, that language was not necessary because this certificate is inherently contingent, because it is not the one certified by the governor and Secretary of State Hobbs. It is by its nature something that doesn't have the legal effect of a contingent thing. And so there's nobody to fool with this. You can't, it's just, this is clearly a slate of electors that's available if we can convince somebody that there was fraud.
I heard that similar argument yesterday, and then I'm asked to ignore what happened in January. I'm not talking about what people coming to the Capitol. I'm talking about the efforts to get the Congress to send it back. One of the reasons it was sent back was because of the competing, or the argument was made, there are these competing elector certificates. I'm not making a finding that that was a true argument or whatever, but I should go ahead and find that it was inherently contingent when those who relied on it said, no, it's not contingent, they're competing. How do I take out of context how they were used?
I think when we're talking about competing and it can be a competing certificate that is inherently contingent. And essentially what the electors are doing, saying, look, and we all agree, I hope, with the court yesterday, you noted the courts should be the place you come to get an answer to these things. Absolutely. And whatever would have happened if these certificates had been accepted, obviously it would have ended up in the courts finally at the end of the day if it had gotten farther down the road on these things.
If my understanding, and I'm certainly not a constitutional scholar, is if that vote wasn't certified, if they didn't do what they did on January 6th, then they're similar to what the arguments that many of these defendants have made. If we didn't sign that on December 14th, we lost the opportunity to ever submit one. Similarly, if the vote wasn't certified on January 6th, it then goes to the Congress to decide. There's no safe harbor in there.
I guess my point is that somewhere on January 6th, as this is happening, it's going to get back into the courts. And I think there was some acknowledgement of that from all of the participants in this case. I can't cite it for you, unfortunately. And I didn't mean to argue yesterday's motion either. But, you know, saying it's a competing slate is not the same thing as saying we are the governor and Secretary of State certified slate. It is saying, going to government officials and saying, hey, there was fraud here. We weren't able to get it into the courts due to the time and so on, but there really was fraud. Please slow down. We have an alternate slate for you if you're willing to do that. It turned out everybody said no. The vice president commented in his book, and it may be that, sorry to keep picking on everybody, it may be that Mr. Colombo can cite page for you, that the director of the count said, oh, we get these all the time. I don't have specifics on the regular slates, but there were no other slates. So the vice president asked, are there any other slates for Arizona? The House official says, no, that was it. They moved on.
But I don't want to more. We talk about, well, it was just the omission of the fact that we're signing this as a contingency. There are people that submit loan applications for which there's a crime if you submit a false one to a federal lending institution, et cetera. So a lot of times people will put either income and they'll put in parentheses estimated, or expenses. They might put the word projected. They make it clear that you can rely upon this, but not with specificity. They explain it away. The lack of putting in, we are doing this as a contingency, like apparently in Pennsylvania, I heard yesterday they did, or somebody did. We keep talking about that it was inherently that, I keep looking at it going, isn't that a fact question for a jury of whether it inherently was or isn't? The words weren't there, and words have meaning.
And I guess my answer is it's a question of law. It's a question of, talking about questions of jury, I don't want to confuse it. The state would have to say this is our case. And then whatever they say their case is that something that the law allows? But the law does not, in these circumstances, create a fraud out of that, because it wasn't saying it was something. It was saying it was something, sure. It was saying we're a slate of electors. We were elected. We're the true electors, the words, whatever specifics they were. But in order to be material to any fraud in this case, which we of course deny, but in order to be material to the claim, it would have to have said, in addition to that, in order to make a crime out of it, we are the people that Governor Ducey and Secretary of State Hobbs certified. The actual lie that we're them, they're not them, we're them. Otherwise, that's inherently, we're just a slate.
Did the Biden electors include that language in their certification?
What you?
Nope.
Well,
Who's saying?
That's me. No.
You just said that it would have to
No.
include that. I'm just wondering whether the Biden electors who also submitted.
No, but I'm sorry, the documents are actually attested to by the governor and secretary. So,
Was they didn't have that attachment. You said they would have to include this language.
right, well, I apologize for saying language, that they would have to purport in some way to have the certificate to be the approved electors.
I understand the distinction. Would this be a good time to break?
Yeah, and I apologize for.
No, you didn't do anything. I've been asking you questions, and for everybody to know, my questions in your ears may sound like I'm arguing a position. I'm really just trying to understand, and I'm thinking of all the questions I would ask, sitting, going over all this, and think I would love to have the answer to this. And I'm making notes of how you're responding to it to help me understand. So I am not trying to argue a point. I'm just, you helped me a lot with the substantially motivated, and I thank you for the work you did last night.
Well, one thing I do well enough is read. So,
Thank you.
Judge, I just have one urgent housekeeping matter, and I know it's 12:10, but I think, as we discussed yesterday, a motion with attachments was filed not under seal with grand jurors' names in violation of this court's protective order. I'd like to approach and talk about that so we could get that taken off the public document, the docket.
Could we do that when we get back at 1:30, or is that?
I mean, right now, there's a public document with grand jurors' names available from the
What
grand.
document was that was filed?
Well, that was us hoping to just approach to tell you. So we have media here, and I would like to do that.
Let's do.
I apologize, Your Honor. One other thing. I'm required to be in federal. This is Brad Miller, represent Doctors Kelly and Michael Ward. I'm required to be in federal court at 1:30. May I be excused and come right back to this court?
Certainly. Does everybody want to chat about whatever this document is we need to address?
We could throw the media out, or it's no one present here is the person who filed it. So I could talk about that.
Okay. Well, let's step back and
Yeah.
just have a quick conversation so I can understand what you're referring to.
and Judge, I just wanted to note, probably to many regrets, I'm actually not done, so I will.
No, I don't think you are. I didn't think you are. All right. Maybe if we can just, no, turn it off the record.
Right this way.
We all going back?